What are the risks of co-owning a property with your kids to avoid the probate process? You are exposing yourself to their liabilities. Now, the liabilities that they may have that you're exposing yourself to could be things like them going through a divorce and losing their half of the property in the divorce settlement, them getting into a car accident, severely injuring someone and having a lawsuit come after them, and that lawsuit judgment taking the equity in that home to satisfy that judgment, or them losing their job, not being able to find another one, and getting behind on their bills, not being able to pay them, and then creditors are coming after them and the assets they own, which is part of the property that you live in. Now, if you have these liabilities coming after you, it could force you to sell your property so that your child can pull equity out of that property to pay off these liabilities. There are other ways that you can set up an estate plan so that your property can avoid the probate process and go directly down to your kids without exposing yourself to these liabilities. Now, if you are not worried about any of these liabilities and you're still going to do that, so you're trying to co-own the property with your kids to avoid the probate process, you don't want to own it as tenants in common with them. And so if you own the property as tenants in common, when you pass away, your half of the property will still have to go through the probate process. It does not avoid probate. If you want to co-own it with them and avoid the probate process, you can set up joint tenants with rights to survivorship. That way, when you pass away, they can file a survivorship affidavit at the county clerk's office, and then they will transfer your half of the property directly down to your kids, and then they would own 100% of that property. It will avoid the probate process. So to recap on that, if you co-own it together, don't do tenants in common, do joint tenants with rights to survivorship so it actually avoids probate. Now, if you are worried about their liabilities and you want to set up so it avoids the probate process without being exposed to their liabilities, you have two main options. The first one is going to be a transfer on death deed and then a revocable trust. With a transfer on death deed, what you do is you have 100% ownership of that property. You would list them as the designated beneficiary of that property. Then when you pass away, all they have to do is file a survivorship affidavit at the county clerk's office along with your death certificate, and they will transfer that property from you to them, and they will take over 100% ownership of that property. While you are alive, you maintain full ownership of that property. You are not exposing yourself to any of their liabilities by them owning the property because you maintain that ownership. There is a caveat here. In Georgia, you have a 9-month time limit from the point of you passing away to the point of when they have the final ability to file that survivorship affidavit and take advantage of that transfer on death deed. After that 9-month window is up, your property will automatically dump into your estate, which is going through the probate process, and it will be distributed per the will or per the intestate laws of Georgia. And so if you have a will and they transfer on death deed and they forget to do that 9-month period and it goes into the probate process, what's going to happen is it will be distributed per your will, not per the transfer on death deed. If you do not have a will, it will get distributed per the intestate laws of the state, which would be an even distribution between your surviving kids and your surviving spouse, with your spouse getting a minimum of 1/3, which may not be how you wanted to distribute that property. So that was transfer on death deed. Now we're going to talk about the revocable trust. With the revocable trust, you can put the property inside of the revocable trust. While you are alive, you would have full control over that property if you are the trustee. You can manage it as if you still own it. Now, when you pass away, it's going to stay inside of the revocable trust and avoid the probate courts altogether. You can distribute that property directly out to your kids and avoid the probate process. With this, that property is protected from any liabilities that they may have while it's inside of that revocable trust because they don't have any ownership of that property. Now, when it is being distributed out of the revocable trust, you have a couple of options. You can keep the property inside of the trust and let the trustee manage it on behalf of your kids. That way your kids do not take over the ownership of that property, and therefore, even after you've passed away, that property is sitting inside the trust and not exposed to their liabilities, which would be divorce, lawsuits, or creditors coming after them, because the trust fully separates that property from them as an individual. Or you could distribute that property out to them. When you pass away, they would take over the ownership of that property, and then their liabilities are going to be exposed, or that property is going to be exposed to their liabilities. So when they have the ownership of that property in their name, divorces, lawsuits, and creditors can come after that property because they own it in their full name, and those liabilities come after the assets that they own. If you want help setting any of this up, click link in the bio, fill out the form, and schedule a time to talk to some on our team.